5 seconds. In so far as the Haryana writ petitions are concerned, sometime in February 1972, the Punjab and Haryana High Court took up the question of confirmation of some of the promoters, including the petitioners, against the permanent posts which fell within the court of promotes out of the 6 permanent posts which were newly created January 18, 1972. Before the High Court could decide the question of confirmation of the promotes against the aforesaid posts, Respondent 3 made a representation to the High Court on February 13, 1972, contending that the ratio of 2:1 between the promptees and direct recruits had to be maintained at all stages, that is to say, not only at the time of appointment but at the time of confirmation also. The High Court appears to have postponed the confirmation of the promotes in response to Respondent 3 representation. Later, Respondent 3 was confirmed with effect from July 7, 1972. 5 promptees, including the 3 petitioners, were confirmed July 8, 1972, that is, a day after Respondent 3 was confirmed. The Governor of Haryana refused to recognize the order of confirmation of Respondent 3 passed by the High Court, and he reverted the latter to the post of a district attorney June 23, 1973. Respondent 3 challenged the order of his revision by writ petition number 2147 of 1973. The petition was heard by a special bench of 5 judges of the High Court, which set aside the order of revision of Respondent 3 but held by a majority that the order of Respondent 3's confirmation passed by the High Court was invalid, since the power to confirm a district and sessions judge was vested in the governor and not in the High Court. The judgment of the High Court is reported in Narendra Singh Rao versus State of Haryana. The view of the High Court regarding the power of confirmation was set aside by the court by its judgment dated January 24, 1975 in High Court of Punjab and Haryana versus the State of Haryana. It was held by this court that the power to confirm a district and session judge resides in the High Court and not in the governor. If this be the true construction of Rule 8, the method of confirmation by rotation of direct recruits and promptees, regardless of whether the vacancy assigned to the particular officer falls within the court of the class to which he belongs, will be in contravention of that rule. It was held by this court in Punjab and Haryana High Court versus State of Haryana Supr that appointment is not a continuous process, that the process of appointment is complete as soon as a person is initially recruited to the service either by promotion or by direct recruitment, and that confirmation is not a part of the process of appointment. The necessity of treating recruitment to the service and confirmation as two distinct and separate matters can be appreciated if only it is realized that recruitment to the service is a matter which falls within the power of the governor under Article 233, while confirmation is a matter of control vesting in the High Court under Article 235. The supreme position of Rule 8, which fixes the quota at the stage of recruitment on the rules relating to confirmation and seniority, is therefore contrary to the basic constitutional concepts governing judicial service.